Judge Ratledge, thank you for your willingness to help the family court bar understand family court a bit better, and just to help us all be on the same page. And I know one of the issues, or one of the topics that's been really foremost in many of our minds, has been this whole concept of e-filing. I think some of us are scared, quite honestly, and some of us feel like we're too old just to understand what's going on. So can you maybe explain the purpose of e-filing for us?
Sure. Let me back up in that. So as y'all know, about 5 or 6 years ago, under then Chief Justice Mark Martin, the state of North Carolina undertook an initiative to really streamline, modernize, and put us all kind of on one system, because they wanted there to be, as has been communicated to me from the General Assembly, some uniformity statewide from county to county. And so they began to develop a system for civil court, criminal court, everything basically. And the purpose of it was to make it more accessible, okay, to folks. Also to potentially reduce some of the load, I think, in the clerk's office in terms of lost papers or things like that. And so in June, well, actually in July, I went to the 2-day training because, as y'all know, this week was supposed to be the rollout of eCourts and our system that we have. It's going to be called Odyssey. And when I went to the training, it was very helpful. I think y'all are going to like the system. I think it is very promising. I think you're going to find it to be user friendly. It was very clear, and Yvette, if I'm wrong on this, let me know. But it's very clear at the training that there's still some kinks to be worked out on this, especially on the civil side. I think the criminal side is much more advanced and more ready to go. But there are a number of hoops that we still have to get through before this thing goes live. One thing to sort of put, hopefully, the folks who are participating today at ease is that though this company who is developing this is out of Texas, they took Los Angeles County out in Los Angeles, California, paperless a couple years ago. And so if they can handle LA County, I think they're going to be able to handle us, in terms of comparing apples to apples and oranges to oranges. You're going to be able, when y'all are using this here in the courtroom, if you have a Jones v. Jones case, you're going to be able to pull up every case associated with either party, both civil and criminal. When you're sitting here in the courthouse or at trial and Billy's telling you that he didn't get convicted of DWI with the minor children in the car over in Avery County, you're going to be able to pull up that conviction and find that Billy was in the car and convicted of impaired driving and had grossly aggravating factors of minor children in the car. So I think you're going to find this to be user friendly. So the real purpose is to get us all on the same page and provide a little bit more uniformity.
And can you tell us how will it impact us on a day-to-day basis as practitioners? And I know I'm probably getting into the weeds a little bit, but yeah, from the time we file a lawsuit until we walk into the courtroom. Yeah,
and Yvette, feel free to chime in because my perspective is going to be a little bit different. So there's a couple different angles to this. What I'm going to see on my screen. So the clerks are going to play huge roles in this. And the biggest thing is that when y'all upload a filing of a complaint and it has the proper, the civil summons and the other documents, you'll be able to do that remotely from your office. You're not going to need to come down to the courthouse to do that. So that's one thing. It's going to save some time in that regard. Obviously, one of the big concerns is when somebody clicks a button saying that they're uploading a complaint for divorce from bed and board, that's really what it is. One of the questions that myself and some other judges had is at training are there humans on the back side of this who are going and checking behind the curtain to make sure that what's being uploaded is indeed what the person uploading it is saying it is. And so we are very clear at training that there are and will be clerks who will be going behind and checking this. So one thing I probably need to clarify is, as good as I think this Odyssey system will be, it is not what I would call smart technology, meaning it is, when you upload something, it is not going to read, and convert and tell you that you have a counterclaim, you have an answer and a counterclaim. Okay, so there are going to be humans on the clerk side, and that you might know a little bit more about that. I'm not going to beckon that you jump in, but if there's something you wish to add on that, please do.
No, you're right on target, Judge, with where we're at. And some of the things and some of the holdup with the launch is some of the business processes and trying to figure out basically what the workflows are going to be. But you're right in saying that when you do upload a complaint, it will go to what we call like a virtual basket, and there will be clerks who are manning that basket, and they'll send it to the appropriate departments where it should go. For instance, if it's a complaint for custody, it will go to the clerks first, they will read it, and then they're going to send it to the family court office, where we will handle doing the judge assignment, assigning a custody mediation, orientation date. Everything that we would do, even if you were here in person, will just be done through Odyssey.
Will it be done like live? I mean, as soon as we file the complaint, do we get the judicial assignment at that same time?
As live as I guess it could be. Those are some of the things that we're still waiting to see how it works. But I know that with it coming to our office, we will be manning it. So just like Faith, who's our judicial assistant, who's at the front desk, she'll take a complaint. She's going to have her computer up, and the new filings are going to come in. And as they come in, she's going to do the assignments. So it will be as live as it could be, I guess. I don't know if I would sit at my computer waiting to see, oh, who's my judge?
Yeah.
We may have a few that we need to get through first, but you will eventually see it. It will definitely be same day. Let's just say it. Let's just put it that way. Yeah.
There will be cues and prompts that will essentially provide an alert to the family court office, where they can then go and just, at the top of the list and work their way down to assign to everybody. And so to sort of, Rose, if I may, to sort of update on why we haven't rolled that out yet, it became very clear when so the judges, we were all broken up into different classes for training. And we had one group go in the second week of July, and then another group go the early part of the third week of July, and then another group at the very end of the third week of July. And it was at somewhere in there, once the training had started for the initial class, and then before it concluded, we were alerted that, hey, e-warrants, the rollout of e-warrants has been delayed. And the reason why that is important is e-warrants must first be rolled out before the eCourts and Odyssey. So when we learned at the end of July, and I had mentioned that to you, Rose, when we were chatting, preparing for this meeting, at the end of July, very early August was when we were alerted that, hey, this is going to be delayed. So how long will the delay be? I'm not sure. I would love to know that we're rolling this out later this year, but I know as much as y'all do. And I don't know. So
we don't have an expected date for rollout.
If there's an expected date, I certainly haven't gotten it. I doubt, and Yvette is part of the implementation team, and I'm not in those meetings, so obviously I'm not going to presume, but we don't have a date that I'm aware of.
No, we don't have a date. We have kind of, what they're doing is pushing out, saying, okay, we think it'll be fall of 2021. I am on the implementation team. I can tell you that there are still some business processes that need to be ironed out. So we still have a ways to go, in my opinion.
Okay.
Anyway, and the last leg before I'm sure your next question is, once this is rolled out, there will be, as I understand, a couple, y'all can probably figure out that, hey, pro se parties, what are pro se parties going to do? What if they don't have a scanner or whatnot? We will have a couple of portals in the courthouse, much like when you go to the airport and you do the, the self check-in, we will have a couple of portals and things that pro se parties, or if an attorney wanted to walk in, that workstations that folks will be able to use to upload. And the biggest difference you're going to see is you're probably not going to see any courtroom clerks pushing a cart full of files, because we are going to be, there's not going to be a backup system for this. We are writing all digital, electronic. And I see you smiling and nodding your head, but that was one of my questions, because I was like, but what about the glorious legal pad?
Yeah.
Paper? And that is not, there is no backup. So let me be very clear about that. Or if there's a backup, I'm not aware of it, but that question has been asked and we've been told there's no backup.
So one of the questions Rob Howard asked is that he's assuming that when you file the complaint, the motion, whatever we're filing, that there's going to be some function that will confirm to the filing attorney that the document has been loaded, or that it's been filed, that you've got some confirmation of filing, just to avoid the problem of statute of limitations or missing a deadline or something. Is that right, a bit?
I believe so. Again, this is, when we went to the training for the staff and for the judges, we just kind of got a snapshot, kind of like here's what it looks like. We didn't get to play as much as I would hoped that I would be able to play in the system and see. But I'm going to assume that there will be something that confirms that whatever you're uploading or filing has been filed. I know that it will be like, how they would file stamp it? You will get a file stamp that's within Odyssey, and you should get that document back.
Yes, I agree with what Yvette's saying. In the judge's side, when we were being walked through cases and when things were uploaded, it looked very similar to what you see on the electronic portal for the domestic violence protective orders, up there in the right-hand corner with a month, day, and year, and then a time minute down to the second file stamp.
Okay. And does e-filing preclude us from filing the old, just going down to the courthouse and filing if we want to?
You're going to go down and file, but whatever you hand over or upload is if you're, my understanding is that when you give the clerks paper, they're going to take it and upload it. Now, what they do with that paper, I have no idea, but it will not translate into them bringing a backup paper file into the courtroom.
Okay, I got you. And how will calendaring be impacted by e-filing?
Great question. I'm gonna have to defer to Yvette. The calendar call's not going to be affected, but right now we have the ancillary. We use the Wake County, the WC FCC calendar, and I imagine that we're going to keep that in place to help us with any transition. What I mean is, in the event we were to be notified that, hey, Odyssey's going live on November 1, we're not going to drop the Wake County. We're not going to stop updating and using the Wake County Family Court website on November 1st. Okay, we're going to have a transitional period because we know that there's going to be some hiccups, but ultimately it will be that calendar on e-filing through which all updates and court dates are set. Yvette, anything as to that?
No, we are going to keep on with the online calendar as it is until we can make a safe transition to Odyssey. As far as how it's going to affect calendaring, I don't think it will affect you all being able to submit your calendar request and notice of hearings. There are some local forms, and I see there was a question before Mr. Howard's question about judicial assignments and whether or not you'd have to submit that form. There are going to be some local forms that we will continue to use that you will still have to submit in addition to your filing. So if you're filing something through e-filing, there's going to be an opportunity for you to upload other local forms that we may still require, like an affidavit of judicial assignment or a calendar request or something like that. So right now, it's hard to answer these questions, I guess, because we're still in the process of trying to figure out what this system is able to do, and what we're familiar with, basically. So it's kind of hard to answer these questions, but I would anticipate, and what I'm fighting for is that you all will still be able to calendar the way you've always calendared, and not affect it too much or impact you guys too much.
And so what I was really kind of aimed at too, Yvette, with the question is, one of the issues that I think is important to practitioners as well as pro se litigants is the ability to look at a calendar, and I would assume it helps the case coordinators as well to figure out, is this a day that we can actually, schedule something on? Because if not, then do we have to call you and say, okay, give us the dates that you've got available? Because that's going to take a lot of manpower on your end.
Oh yeah, for sure. And that is one of the things that I have been asking constantly, whether or not the public attorneys will be able to see what dates are available for them to calendar on. And I haven't gotten as sure of an answer yet on that, but I am going to continue to keep asking that question because I think it's important for us to be able to allow you guys to see what is available as far as calendaring. So as soon as I get that answer, we'll get it to you.
And one thing that's helpful too for folks to know is that the 2-day training that Yvette and I had, and we were all in separate rooms and whatnot, that's not the extent of our training. We were told that we're going to have another 1 or 2 sessions. So some of the questions y'all have as far as features are great questions. It hasn't been shown all to us yet. And so I want to make that clear that this isn't a situation to where in between now and when the green light is finally given, we're going to have more training. So.
And Judge Ratledge, Yvette alluded to this, but I am assuming with e-filing that there are going to be some changes to our local rules, which will require us to go in and make changes to comport with whatever's going on with e-filing. Is that right?
Yes, and great question and great segue. In talking with Judge Walzek, I know that yourself and several others worked very hard to update the family court rules, and those were slated, and as I understand it, talking with Judge Walzek, those were slated to be rolled out or at least pushed ahead for adoption in the early spring of 2020. And then the impact of COVID hit and this got put on the back burner. And so fast forward to middle of the spring here, when it came time to revisit these, there was several different conversations on what to do with the family court rules. Answer your question directly, yes, this eCourts will have an impact. It will cause us to revisit the family court rules. Some of our terminology will change because we'll have a different vocabulary in dealing with eCourts, but I think you'll find a lot of similarities and it will be user friendly. But we are going to have to update those family court rules. One of the real heartburn this past spring, and it was very cordial, but the challenge was gosh, if we roll out these family court rules at the time when we were all signing up for eCourts training in May, and y'all were getting notices that we were having to limit family court in late July, we were all under the impression that eCourts was going to be rolled out at the very end of August. And the sentiment was, gosh, we need to go ahead and put out some of these updates, because I know the family court office was in dire need of a couple of things, as y'all were. But we didn't want to roll out these rules only to then flip them and have to change them 5 weeks later. And so the decision, there was a couple different conversations. The decision was ultimately made to delay rolling out the family court rule or asking that those be adopted. That decision was made I believe in June. in the middle to the latter part of June. Again, at that time, we were all under the impression that Odyssey was rolling out in 2 months. And then 3.5 weeks later, we get informed that the brakes are being tapped. So we are in a bit of a no man's land right now. So I hate it from the standpoint that I know so many people worked hard to update those rules. And Judge Walczyk and for y'all as a stakeholder, y'all put a lot of time. So I want y'all to know that your time was very much appreciated, and it's not something taken for granted by myself or the family court staff or the other family court judges.
Well, before I switch to another topic, Judge Ratledge and Yvette, are there any other comments that you would like to make about e-filing before we change topics? Anything that I didn't ask you about?
Not that I can think of. I know that somewhere down the line, there's going to be some training, I believe, for attorneys in this. And as that information is provided, Judge Ratledge and I will speak, and we'll get updates out to you guys when that comes out. I want to make sure that you all are aware of whatever training is available for you on the system. I know that there were a couple of, I think, town hall meetings that were set up, and I'm not sure if a good amount of you or a large percentage of you were able to attend any of those town hall meetings, or if you even knew about it. There was a little wonky, weird thing going on there with communication.
Okay, thank you. So, Judge Ratledge, what would you say has been the court's biggest struggles in dealing with both attorneys as well as litigants during the pandemic?
Yeah, I'm going to go with the first answer that came to mind. With the pandemic, folks are a little bit more on edge, and I think a little less patient with each other. From my view, I've noticed throughout this whole process that, people are always, anxious when they come to court anyway, because they know that there's an ongoing dispute. But I've noticed since March of 2020 that folks are just a little bit more on edge. I don't know how to explain it more than that. I think attorneys, from what I can tell, are a little bit less patient with the other, and don't seem to quite be thinking the best of the other and assuming the best. And so I can't speak for the family court staff on the 11th floor outside of what I've seen. I get the sense that that's probably spilled over and affected them, just in the things that I hear back. If Yvette wants to chime in, that's fine. No offense taken if she does not. I won't ask that she do so.
What suggestions or tips do you have for us as practitioners in dealing with the court as well as the case administrators, the family court administrators?
Sure. Great. I've got a list of about 6 or 7 things. It's a document that I provided that I hope will be made available to everybody at the end of today's presentation. So if y'all want to grab a pen and paper and write these down, great. If not, if you want to just listen along, because you'll get the copy at the end. The first thing, your particular, as a lawyer, your office gets your angry clients daily, but the family court staff gets everyone's angry and annoying clients daily. So just remember that and be considerate when you're communicating with them, because each given office, hypothetically speaking, I'm saying let's say you get 2 or 3 angry calls, but the family court office gets 40 or 50 angry calls. And so they're human, and that wears on them. So be mindful of that. The second thing, this has popped up before. I am aware of this. I think this has probably happened to some other judges, but limit your emails to the family court staff on matters involving case management, such as court dates and order submissions. A lot of times, and I don't know that it's necessarily intentional, but the case coordinators get caught in the crossfire of disagreement between attorneys. And a case coordinator steps out in the lobby or office to help somebody, a walk-in, and then when they come back, they have 7 emails between crossfire of attorneys arguing about something that really the case coordinators don't really need to be put in that situation. So it puts them in the situation of, wanting to type the words unsubscribe, if I can so indulge, or just that awkward position of going, gosh, I've got 6 emails from these attorneys. Do I really need to respond to these? And so that's the second point. The second is when filing, please don't edit our domestic forms anyway. I'm aware of 1 or 2 that we've got some typos on or that need to be fixed. And I think those will be addressed in the near future. The fourth thing is be mindful that several of the family court staff are still learning. There's different levels of experience there. So some of them are not as familiar with the legal terminology. Okay. Any questions so far on those, Rose? I'm about halfway there.
No, I think you're good.
Okay. The fifth point is when in doubt, and I don't remember law school professors did this, but I really don't mean it this way. But when in doubt, read the rules and don't rely on the family court staff to give you legal advice. Like one example of a common issue that we have is like whenever you're setting a case, whether you're on the calendar or not, you've got to consult with the opposing party's attorney. I think the family court staff gets a lot of notices which indicate that they haven't consulted with the other side because maybe that lawyer's on the calendar that day anyway, and they can just appear. So that's one example. Be sure to read the rules. This next one is one that has popped up more and more, but when you're submitting a consent QDRO, which does not already have a family court judge assigned, just submit that QDRO to the family court office without attempting to pre-select any judge for it to be assigned to. The family court staff randomly, but purposely, there is a method to the madness. They distribute those among the judges so that the caseloads are more evenly distributed and fair for all of us. And so there's a reason why if you've submitted something and it's got my name on it or Judge Stevens' name or Judge Bell or Judge Howder, you may get that back with a line crossed through it and it's handled by a different judge. That's why. It's not because somebody's looking to argue with you. It's because, hey, we had 11 of these come in today and we're divvying all these up accordingly. Last thing is if attorneys are still sending in new filings by mail or dropping off to the family court office, just ensure that you provide a copy of the complaint and the affidavit of judicial assignment and all other required paperwork. I think those are some helpful tips to remember when communicating with staff. Yvette, is there anything that needs to be added on to what was already stated? And you don't need to feel the need to do that, but I know that you run that office, so you do a good job.
Thank you. No, you covered it pretty thoroughly. Thank you.
Thank you.
So what can we, Judge, as lawyers do to make things a little less burdensome for the judges as well as the case coordinators?
Great, thank you for that. I took a poll from the other family court judges on this question. I asked them, and I even asked another judge who will remain unnamed, but who frequently is in 2A. And so here are some things that were told in response to me, to my inquiry. When an order is due, make sure that it's submitted on time based upon the due date. I realize that life happens with y'all, and other judges do too. But when that's not submitted by the due date, it really leaves the case coordinators from a case management and the judges from a case management perspective of having to chase that down and send an email or make a phone call. Stick to that due date. The second thing, this one was echoed, is try the cases that really need to be tried. Discourage your clients from focusing on really trivial matters. I'll leave it at that. I know that y'all are, doing your best to make a living and advocate for your client. Some things, your client may want you to try something, it just doesn't need to be tried. Okay, I'll leave it at that. If your cases resolve in advance of their court date, please let us know before the morning calendar call. So hypothetically speaking, if you're on calendar for a trial tomorrow and you're number 1 or number 2 and it's resolved, go ahead and go ahead and send that email to the case coordinators instead of them having to chase you down. Here's another one, and this has kind of been an issue, and I probably will spend a little bit of time on this, but monitor the calendar. And if you're one of the first ones up the very next day, be in the courtroom or near the courthouse for the calendar call, and be ready to go so that we don't lose time. This has been, WebEx has provided a great convenience in one aspect. It's great for motions to withdraw. It's great for very, maybe quicker things like maybe motions to compel that can be handled remotely. But with the benefit of the technology, it has also caused us to lose precious court time. I myself and other judges have spoken, whereas before we'd call calendar and then we'd get rolling in a trial by 9:30 or 9:40. As y'all can imagine, if you have a contested custody hearing, and the plaintiff's attorney lives in Raleigh, but the client lives up in Wake Forest, and then the defendant's attorney lives in Cary, but their client lives over in Smithfield, all it takes is one of those parties to be 45 minutes away from the courthouse. And we don't always have little fillers that we can put in, like, domestic violence protective order motions to renew. And so what we have been finding and struggling with is that probably on average, it's not unusual to lose 30 to 45 minutes a day waiting to get that first trial off. And y'all know from 2020, we had a grand total of 4 months lost of court time due to the 2.5 months of shutdown, and then 2 weeks in November, and then another month from mid-December to mid-January. And so when you do the math, if I lose conservatively 30 minutes a day times 4 days, let's say I have an admin day, that's 2 hours a day that I lose. You multiply that by 2 other judges, or even 4, that's 8 hours a week. You multiply 8 hours a week over the course of the year, y'all can see how that contributes to us tackling that backlog. So if you're up, or that you're going to be coming in for a trial, get your client here. Be ready to roll. Be in the courtroom ready to roll at 9:30. Next thing is make sure the emergency custody case you're filing is or has some emergency element to it. We have seen, and that it's not just because you're trying to get on the calendar because you can't get on the calendar. Your next available court date's 4 months. That was one that was expressed. I guess we've seen a number of those. I don't know that adequately describes all the emergency cases, but that has become an issue. Last but not least, and this helps with the case coordinators and the judges with our case management system, is that when your consent order states that one party, let's say y'all have agreed and you're disposing of all issues, when your consent order states that one party is going to be filing a dismissal that day or in the next 10 days within entry of the consent order, make sure that you timely file those dismissals. It may not seem like a big deal to y'all, but from our case management system with what we have right now and with what I assume we're going to have with Odyssey, the failure to enter in that dismissal within 5 days or 10 days, as you and your client said that they would, it causes enormous additional case management duties for the family court office. I won't bore you as to why, but it really does. And it's one of those things. I don't think it's nefarious or ill-intentioned. It's just probably, hey, you forgot to file it, or everybody knows it's resolved, or let's be blunt, maybe your client stiffed you and you don't have them. They didn't pay you to do that, or they ran out of trust funds. So those are some tips that were given to me from 4 other judges, not including myself. So,
well, thank you for those. So one of the biggest obstacles that I think that we face, as practitioners, really and you hit on it, Judge Ratledge, is getting calendar time, and oftentimes just not having enough time to actually try the case that we want to try. And I know these questions, the answers you're going to give are specific to you. You're not speaking on behalf of the other judges, but I'm curious, when we understand the backlog, why do we close the calendar? Why not let us as lawyers just add the case to the calendar, and knowing that we're taking the risk that we're not going to be reached, but we take that risk?
Sure. Fair question. Case management and how big a given calendar is on a different day is an ongoing topic, not just for Wake County. I know Wake County is why y'all are asking, because that's what we're doing, but it's something that I think various counties struggle with. The biggest reason that we do cap the cases is just from an administrative standpoint. One, we have to be able to get through the calendar call. If we let people calendar their cases and the amount of time without having some boundaries on that, this calendar will get out of control and it will become unmanageable. We also have to, and the reason why is if we don't put caps and we don't close it, we're going to go from having 12 cases with 25 hours. You may see it just become a free-for-all to where we've got 13 cases with 78 hours every day. And then it can expand so large to where it actually defeats the purpose, and people don't think they're going to get reached because ahead of them are 6 cases, everybody asking 10 hours each. And so there is a tension. Different counties do it the different ways. I've wrestled with the thing you're talking about, because as the judge, I don't know what the issues are. Y'all know your cases better than me. But we have to put in some sort of thumbprint to keep this to where we're moving, and to where other people have an expectation of whether or not they're going to be met.
So does each judge have a specific number, that says I don't want more than 40 hours on any particular day, or does it just vary? Or
I tend, and Yvette, if you want to chime in, I'm not going to ask you to chime in for any particular judge. I don't know, to be honest with you, what Judge Bell and Howder and Stevens's position is on that. I've kind of lived through the extremes. When I first got on family court, I don't know that we had a whole lot of cap, as I recall. And then with COVID and the protocols that came in place, we did restrict it, because we were trying to balance the foot flow and traffic in the courthouse, but also reach things. That was a delicate art. And now we have some things capped, because I've lived in those extremes. I don't have a specific number of, either number of cases or number of hours that I have passed along. If the matter, I defer to Valerie on that. Yvette, do you want to chime in just from a 60,000 foot view?
I think it varies. To answer the question that Rose asked, I think from judge to judge, it depends. It depends on what the calendar looks like. It depends on what type of cases are on there. Sometimes, just like Judge Ratledge defers to Valerie, that could be the case as well. A lot of times when attorneys are asking, though, to be placed on a closed calendar, like the local rules indicate, we do take it to the judge and ask them, we give them a snapshot of what here's what the calendar looks like. They're asking to be placed on a closed calendar, and then we defer to the judge to let us know whether or not something can be added. But for the most part, it does vary from judge to judge, from case coordinator to case coordinator.
Okay, thank you. And then one other question, as far as the scheduling is concerned, Judge, again, knowing this is, we're dealing with you, what do we do? We get a case that we really believe, when we schedule it, that it really ought to be a 2-day trial. But you know, once you get into the weeds, you think, oh my gosh, it's now changed and I'll be lucky if I can finish it in 4 days. What's your advice? What do we do? Do we ask you for additional time? Do we take it off the calendar and find 4 days? What do we do?
My initial response, I wouldn't take it off the calendar. I would submit a written request as to why you need the additional time. I can tell you, Valerie does a great job. If something's in particular with this issue, if you're set for a 10-day trial, or 10-day, a 1.5 day trial, sorry, and you think you need more than that, when you submit that to her, she brings it to me and I do review it. There have been times where I have granted a 1.5 day trial to then expand to 3 day because there's good reasons for that. But you're gonna have to be specific, not just because it can't just be because, hey, I've got a couple more witnesses. I mean, you need to know, are these experts that we have to accommodate for their schedule? Was there a report that wasn't available to y'all that still is, or that now is available? I have gotten plenty of requests for that to expand and I have denied them. So I don't have a blanket, what you get, and it can never be changed unless you remove it and get a new court date. That's not how I operate. So if you think you need more time, by all means request it. It's just like when I'm on counter call and I'm having to continue a motion to modify custody, and maybe it's the second time I'm continuing it, and someone will inevitably say, well, Your Honor, the court date that you're giving us today, can we go ahead and get a peremptory? And my response is, you need to submit that request in writing. Not being disrespectful, I remember early on last summer with COVID and things being hit, I got inundated with the cases we didn't reach. I got inundated with a number, almost everybody was asking for a peremptory, to where the peremptory was just part of a normal request. And so it is what it is.
We had a question from one of the attendees asking if you could elaborate again from your perspective on what constitutes an emergency.
Well, typically the emergency comes in, we're talking about deals with a custody case.
That's right.
Where a child has, where the belief that a parent has taken the child and is attempting to escape North Carolina for the purposes of evading jurisdiction, and or that the minor child or children involved are at substantial risk of exposure to physical bodily harm or sexual abuse. Those are the type. That's what I mean. I was referring to the definition and what has expanded from case law out of Chapter 50. Okay.
And is there a limit on the number of days that a party can request for a hearing?
Yvette, you can answer after me. I don't have a limit on that. I will get asked from time to time. So there have been a couple of ED trials in particular where I have been asked for a full week. There's one or two that I was asked about that I granted because the amount of assets were pretty enormous. But I've also been asked for, 5 days before on a motion to modify custody, and I didn't grant that. Somebody's got to give me a reason more than just we haven't been heard. So as a general rule, I don't have a maximum. Yvette, do you want to address anything related from what you hear up there?
I guess from a case coordinator's point of view, we're used to seeing, certain amount of time for a specific issue. If it seems to be excessive, like what like the example Judge Ratledge just said, like a motion to modify, you need like 4 days or something like that. We would bring it, or the case coordinator could bring it to the judge's attention and say, listen, they're asking for this, just for this. Are you okay with that? Is that okay? And a lot of that also comes with, some inexperience, not knowing whether or not that is permitted or not permitted, and then just trying to get a handle on, how calendaring is supposed to happen. But as far as I know, there's no limit on how many days you can ask for. But if something appears to be excessive, especially with us experiencing this backlog from the pandemic and just trying to get everyone on the calendar as much as we can, sometimes that question could come up. A case coordinator could address the judge about that.
Thank you, Yvette.
Yeah, and just one thing, and I want y'all to know, largely because of the calendaring caps for issues, it's not like I get asked for every calendar request. I don't get asked for, hey, do you approve this or not? This is largely governed and managed by the case coordinator. That they will bring things to our attention when it seems to be, a half hour. If somebody's asking for an hour and a half for, maybe a PSS issue, that may not reach my attention, even though we're going to give it an hour. But, when you're asking for something way beyond, if it's two pro se parties, like I had one the other day, and they want 2 days for a custody trial, I got to know why two pro se parties are wanting 2 days for a custody trial. Okay.
Right.
So it's the exception to when I get presented with a calendar request on whether to grant the additional time.
So can you talk about virtual calendaring or calendar call? Because obviously the pandemic has caused us all to think outside the box, but your thoughts on virtual calendar call, the likelihood that it will stick around, what do you think?
Well, as I've shared and alluded to earlier, the virtual calendaring has brought about some benefits, because I do think it is helpful for the lawyers. You don't have to pay for parking and come down for that motion to withdraw from a case. It's been, I think, very effective for Friday divorces. There are some things that do make it fruitful. Look, y'all, I understand the type of case that you have, particularly if you're wanting an equitable distribution trial. It's darn near impossible to try an ED case remotely, and our rules don't even allow it at this time, although the parties could request and the judge could, I guess, grant it. But the downside to having the WebEx is that delay that I talked about earlier. In the exchange, in the trade-off of the benefit, we have lost sometimes a sense of urgency to get to court. And so, the productivity in terms of reaching cases, I think, has been challenged. I get the sense in talking with other judges that we're starting to have our case coordinators reach out to parties and to be here in court the next day if they're ready to go. Probably what's been missed the most, and this was an issue that was brought to my attention a couple of weeks ago, is attorneys are human. Y'all are human. I think probably the interaction that y'all need and that you need to have with each other has probably suffered by not being down at the courthouse and seeing people and catching up on life and whatnot. So that's a tangible loss. I anticipate, to be direct, I anticipate that we're going to have calendar call remote will remain in place, but it's not. I wouldn't say it's a forever thing. I mean, this can always be revisited. Frankly, if we don't see, I think some more regaining some lost time in those gaps, we can't mathematically lose 7 or 8 hours of court time among 4 judges throughout the week and think that that's okay. And so if we continue to lose time with this, I could see this being revisited.
Okay. And Rob Howard commented and said, do you think fewer cases are settling on the courthouse steps because we're now doing virtual, the calendar call remotely?
Gosh, I don't know what our numbers show on that. It's hard to say. My general sense is that may be the case, but let me add an element to that. I don't think that it has to do as much with remote calendar alone. We've lost, because of this, we've lost in-court custody mediation.
Mm-hmm.
That's a big deal. So given the fact that it's remote and given that we've not have in-court custody mediators, be able or willing to come down because, a number of considerations. Like I think it's a combination of a number of things that have probably led to some things not settling that otherwise normally would.
Okay.
I think it's more of a totality picture.
Judge Ratledge, we see, I mean, I don't know what the percentage of cases are that are tried, but my gut would be that most of them are custody related. I mean, the significant litigation. Would you agree with that?
Yes, ma'am. I would say custody makes up, gosh, if I were to do a search of my notes, I would say custody makes up over half of the cases that I hear. And when I say that, I mean true temporary custody, permanent custody, modifications, and then show causes that arise out of a party not following the custodial order. I think that's probably, I'd say 50, half to 2/3. Yes, ma'am.
So practically speaking, you're the judge, you're hearing a custody case. How many witnesses, school teachers and neighbors do you really want to hear from?
I don't look at it that way. I look at it, what's the issue that's being alleged, and based on what's being alleged, did the party present the evidence? So if I need to hear from 3 teachers, then I'll gladly hear from 3 teachers. I don't think in terms of a paradigm that I only need one of each category kind of thing. And so if it's a critical incident that involves domestic abuse of a minor child and one party's asking for modification based on that, then, I'm probably wanting to hear who the witnesses are, hear testimony from anybody that observed that, the doctor's report, the impact, the therapist, who talks about the impact the child has endured. So I hope that answers your question. I don't think in terms of, I got to have one, splice one from each category.
Yeah, and I got time, I think, for one more question. Our local rules require, when we need to get records from therapists, doctors, healthcare providers, we're supposed to send it down to the judge for you to review, sign the subpoena. Yet we find some lawyers are still signing the subpoena themselves.
Mm-hmm.
I mean, have you had that issue in your courtroom?
I have, and I don't know it until I'm already in the trial. Ironically, there have been times, even this year, where once we get started and I'm looking through the file after I'm doing my quick file review before the hearing or as we're in the opening parts, and I will see where one attorney sent a subpoena for records. And I think to myself, wow, how come I didn't sign this? Not from, this attorney is terrible and needs to be reprimanded, but sometimes it's a situation where both attorneys have done it. And we really need to get a better grip on that. I would not say that I have found this to be a widespread issue, but I guarantee I've probably seen 3 to 5 cases this year where I've been on the bench. And of course, I don't know that that's happened until it's too late. We're already in the hearing, or we're at the motion stage at the front of the hearing, and it comes out that one attorney did the very thing that you're talking about. And so, yeah, because I'm not aware of every subpoena that's sent, but hopefully when an attorney's is in receipt of subpoenaed materials, hopefully they are noticing the opposing counsel and making them aware of that. But yeah, you raise a great question. I'd like to, I think myself and some other judges would like to see that shored up.
Yeah. Judge, thank you and Yvette both for your time and for your input. It's been most helpful, I think, for all of us. And I think I speak for everyone that we really do appreciate it.
You're welcome. Thank you, Rose. Thank you, Yvette. I may observe a little bit of this next session here for a bit, but hope everybody has a great Wednesday.
Thank you.
Thank you.
Thank you so much, Rose and Yvette and Judge Ratledge. This was wonderful, and we're going to. I just wanted to send a little reminder that if you want credit for today, make sure that you return my email with with your bar ID number and your full name, so I can make sure you get credit. If you're only here for half of the presentation, just let me know, and we can do a partial credit. With that, please get me that information by 4 o'clock today, if you possibly can. That would be very helpful. I have over 55 emails, so I know you're hearing me and doing that. I appreciate it. I'm going to turn it over to to Judge Fred Morelock now. Thank you so much for being here.
Thank you. Welcome to the Ethics Hour. My name is Fred Morelock. I practice with the Family Law section here at Tharrington Smith. And my co-presenter today is Brian Oten. He is with the Office of Counsel with the North Carolina State Bar. Brian?
Fred, it's a little different now. I'm no longer with the Office of Counsel. I'm the Chief Ethics Counsel for the North Carolina State Bar. So I don't deal with discipline anymore. I'm here to help you lawyers navigate these tricky waters of legal ethics.
My bad, and I'm sure that won't be the only mistake I make in the next 60 minutes. Brian and I did this a couple of years ago. I wish we could be live. It was a really enjoyable back and forth presentation a couple of years ago. This is a bit recycled, but it's certainly updated. So Brian, you want to kick this off?
Yeah, I'll go ahead and share my screen. Make sure everybody can see that, Fred. Can you see that, Sandy?
Yeah.
Are we good? Okay.
Yeah.
Well, let me add my thanks to you all for,
Thanks.
great, thanks, Sandy. Thanks for having me, and thank you, Fred, for inviting me to crash your party. I want to start off with the general discussion about the ethics update for family law practitioners with a quick reminder that there is an ethics hotline that the State Bar offers. It's mostly by email these days because of the back and forth between sometimes we're in the office, sometimes we're working remotely, depending upon what's going on with whatever variant is out there. But the bottom line is, if you shoot an email to ethicsadvice@ncbar.gov, you should receive a response fairly promptly. Certainly, if you have some sort of emergency situation that you need ethics advice right then and there, please do put that in the subject line so we can get back to you and triage, prioritize as appropriate. Our informal advice to you all is entirely confidential. So we want to give you all the best advice that we can as you try to navigate the different professional responsibilities that you have with regards to the relationships that you have with your clients, the court, different responsibilities overall to the profession and the administration of justice. And those can get really difficult sometimes. So, we want to step alongside you to make sure that in our job of protecting the public, we can help you all maintain those appropriate ethical standards. So feel free to reach out to us. Fred, we talked about questions that typically don't get answered. And we have this slide here just to clarify. There are a lot of things that we will answer. We'll talk about your prospective conduct. We will advise you on things that if you're presented with a fork in the road, which path do I take? We'll be happy to again, step alongside you and kind of figure out what is the best pathway. But there are some things that we don't answer. And you can see them here on the slide. Things where the material facts are in dispute, inquiries requiring legal interpretations rather than ethical interpretations, conflicts of interest that are pending before a court, or blessings for actions that you've already taken.
So let me jump in there and want to ask you, I'm certain you get these from time to time, but let's say I'm troubled by what an opposing counsel is doing in my case. And I learned that that lawyer has advised her client to delete text messages. And I call you and I say, can she do that? And is that a violation of the rules?
And I would say, I can't answer that. We do not offer opinions on other lawyers' conduct. The thing that we can talk about, and I often have this conversation, because it sometimes leads to kind of the way that your suspicion or maybe your knowledge impacts your professional responsibility, and that is the duty to report. We're going to talk about the duty to report a little bit later on. And
That
so
was my next question.
Yeah.
Should I report the attorney? And we're going to get to that a little bit later, but let me take it a little bit further. I recently told a client to text messages. Is that a violation of the rules?
Well, I can't answer that either, Fred, because you're asking me to offer an opinion on something that you just did. And we can't offer a blessing.
All right, how about a hypothetical? Let's go with a hypothetical. I am thinking of advising a client to delete her text messages now that you've refused to answer all of my.
Now that is something that, of course, I'll say, if this is all in the same conversation, it's very cute that we're converting past conduct to now potential prospective conduct via hypothetical. But that said, yes, we can talk about prospective conduct. And certainly, you know, that also does bring up another aspect, though, of a legal issue, deletion of text messages, and the whole issue of spoliation and things of that nature. So we can talk about some of that stuff, but quite frankly, if you ask me about your past conduct and then say, well, hypothetically speaking, what if I was thinking about doing this? Then I may still respectfully decline to offer an opinion.
Okay.
So that's I guess the general gist. That what you're learning here is just talk about your prospective conduct. And if you're asking for a blessing on your past conduct, just lie to the state bar and say that it's a hypothetical. No, I'm kidding. Don't do that. Let's not do that. Let's get into our update for the ethics program at the state bar and the different developments that we've had. Now, you all know, or you're all familiar with a lot of the things that the state bar does. Of course, we deal with proposed rule amendments and formal ethics opinions. Those things get published on a pretty routine basis from the ethics committee. Generally speaking, those formal ethics opinions are supposed to consider matters of general interest. They're not necessarily going to be tailored to one specific fact scenario that's incredibly unique to just one person. We'll deal with that in another way. But these ethics opinions usually are things that we think everybody would be interested or they would benefit from hearing about. All of our proposed rule amendments, all of our proposed ethics opinions get published for comment before they actually get adopted. They get published on the State Bar's website as well as in the State Bar Journal. That gets mailed out to everybody. We throw them up on social media to let everybody know that those things are out there. So we try to get the word out the best that we can. We also have a podcast these days. Feel free to tune into the State Bar's podcast. I think we had as many as 60 listeners this past quarter. But the big thing that I want to stress is that if you submit a comment, your comments will be considered. Truly, we want to hear from you. The ethics committee is comprised of a number of lawyers from across the state, across a wide spectrum of practice areas. And so we'd like to think that when we publish something, we've found the best answer. But that's not always the case. You know, sometimes we need to hear your perspective on a particular issue. If you agree with an opinion or a rule amendment, we want to hear that. If you disagree, we want to hear that. Particularly, I have to say, if you agree with something, I would encourage you all to consider shooting a quick email over to ethicscomments@ncbar.gov, just saying, I read this proposed opinion and I agree with it, because silence doesn't necessarily mean that you agree with something. Sometimes it may just take one or two individuals to write in opposition to a particular proposal that ends up derailing the whole thing. So please do offer your comments, whether you support something or oppose something. Every comment gets considered by the ethics committee.
So let's talk about what's pending now, some of the issues that are currently before the state bar.
Sure. So we've got we've got two opinions that are currently published for comment that I would love to hear from this particular section, the family law practitioners in Wake County, hear your opinion on these things. The first one is this opinion that deals with a lawyer's responsibility in handling contraband, which is a very kind of broad statement, but it's really specific to to domestic practice. This scenario that was presented, and this actually came or originated from the grievance committee and sent over to the ethics committee for some clarification. But the scenario is this: it's that child custody situation where lawyer is representing mom, and mom doesn't want dad to get any amount of custody, and mom, as proof of how bad dad is at supervising their kid, sends over to lawyer a bunch of pictures, sexually explicit pictures of mom and dad's minor daughter, saying, look what I found on her iPad while she was under dad's supervision. He's not supervising her at all. There's no allegation of inappropriate behavior on dad's part. It's just that dad isn't doing what he's supposed to be doing and taking care of and raising our child correctly. He's not paying attention, and this is what's happening. And so mom gets all these pictures off daughter's iPad of her, whether they're just sexually explicit, maybe they're exchanges with a boyfriend, whatever it is, and just emails them to lawyer. Now lawyer automatically is in possession of sexually explicit images of a minor,
So,
which
Brian,
is illegal.
let me interrupt you right there and say what we're talking about when we say illegal contraband. This would be evidence, pictures, and so forth that would be a violation of law to possess.
That's correct.
Oh,
Yeah,
okay.
just the possession of this material is illegal. And so the question that was posed to us is, what can a lawyer do?
So that would include a client who comes into your office, the same mom comes in your office and says, look what I found. Look what I found at home in my husband's sock drawer, and it's a bag of cocaine.
Right. Yes. And we actually have an opinion on that type of scenario. This one was a little different because the inquiry and the situation that's, I guess, sadly been developing is that lawyers have suddenly found their inbox filled with emails from clients. They don't have any control over that. They can't say, don't bring that in here. You need to turn around and walk away. Lawyer now possesses it. And so the question that was posed that's currently out there, again, this opinion is proposed. It is not adopted. But the question is, essentially, what should a lawyer do in that scenario? And the answer, the proposed answer right now is that, essentially the rules of professional conduct cannot overrule statutory requirements. So if the statute makes it illegal to possess that information, we can't say, well, the rules of professional conduct somehow allow it, even if it's relevant to the client's case. So it's the instruction from the opinion is essentially kind of twofold. One, lawyer needs to get rid of it, but two, contact the person who sent it, namely the client, and say, we need to talk about whether or not you're allowed to possess this. But then, and maybe I'll say threefold, because the third prong is lawyer needs to look into whether or not he or she now has a reporting obligation under the law if they find that these images actually indicate some sort of child abuse.
Okay, let's go quickly to an issue that I was not aware of and had to learn about myself recently, and that is the Google screened advertisement program.
Yeah, so this is something some of you out there may be familiar with this new service that's offered by Google. They offer a lot of different keyword advertisements and things of that nature, but they have something called local service ads or Google screened ads. And essentially, it's something where you can apply for an advertising program through Google. Google then verifies your credentials as a service to their consuming public to say that, yes, we actually verify that this person who says that they're a lawyer is in fact a lawyer. We check their licensing credentials and things of that nature. The opinion doesn't really talk about that stuff because that's really addressed in a prior opinion from 2018 dealing with another kind of third-party advertising that's verifying your credentials and so forth. What this opinion does is it looks at one of the other, frankly, troubling aspects of that program, and that is that when you sign up for this program, Google creates your advertisement through their search engine. So anytime somebody's looking for a family law lawyer in Raleigh, they might see your ad through this local service ad, and they'll see a little phone number right next to it. You click on it, and you're connected to the firm. The problem is that telephone number is not the lawyer's direct number to the firm. It's actually a Google number that sends the communication to the firm. the lawyer, in signing up for the process, signing up for Google service here, they've actually consented to, one of the terms of that service is that Google gets to use their telephone number to send that communication. But in doing so, Google is also going to record the conversation that the client is having with the lawyer. Now, making it even more scary is that the terms of service say that Google can record and they can retain and potentially disclose to third parties that actual recording of the communication. It's fraught with all sorts of issues. I would encourage you to take a look at the opinion. It's out there again on the State Bar's website. I'd love to hear your thoughts. I know advertising can be a really important thing, and there's a lot of different technological advancements in advertising. So certainly the State Bar wants to strike the right balance to enable folks to take advantage of their commercial speech avenues while also recognizing the potential pitfalls and really the detrimental impact that some of these mechanisms can have on clients, and particularly client confidences.
Let's go to those issues that are pending in subcommittee, and you've got about 5 issues there, and I really want to skip over the last 4, but go to the first one, which is confidentiality of information, which is also in the public record. Now, my understanding of this from a long time ago is that if I learn something about my client or about the facts of a case, and I learn it through the representation, my client has told me this information, and we go to court and we're trying a case, and this information comes out in court. I cannot discuss that fact, that evidence, without my client's consent, because that's confidential information that I received during the representation. However, if you, Brian, were sitting in the courtroom unconnected to the case and heard this information, you would be entitled to go out and talk about it. So
Right.
tell me about this disconnect.
Sure. So this is, and Fred, this is, we have, I'm going to address this in a couple of slides. We do have some other recently adopted opinions. Do we want to hit those up? Or do you want to move right to Rule 1.6?
We can wait to get there. I've just kind of laid the groundwork.
Let's hold off on that one, because I think I want to just kind of go through some of these recently adopted opinions to make sure everyone's aware of that before we get to that, because that's going to be a much more involved conversation. It's something that I would encourage everybody that's on this call, feel free to pay attention to and weigh in with the State Bar as we explore the rule on confidentiality. But let me kind of address some of these recently adopted opinions. The first one is 2020 FEO 2, which deals with advancing client portions of settlement. This is that scenario where you essentially have resolved your client's case, typically a personal injury case, but it could be a variety of other contexts, where you have received settlement proceeds from the other side. Client is saying, I want that money now. I need that money now. And lawyer is basically saying, everything is essentially wrapped up. Can I just give them the money out of my operating account? And then once the check clears my trust account, then I'll go ahead and reimburse myself. Is that permissible? Well, the opinion essentially says that if the litigation is still pending or contemplated, then no, you cannot provide financial assistance. That's Rule 1.8E. There's been a longstanding prohibition on providing financial assistance to clients when you are representing them, you're involved in pending or contemplated litigation. There's a variety of reasons for that. Probably don't have the time to really get into all that right now. But nevertheless, that's been the longstanding rule, and it's really a pretty uniform rule across the country. The situation, though, that we're looking at is essentially when a lawyer has determined the litigation is no longer pending and it's no longer contemplated. You know, all the settlement disbursements are signed. You've received the check from the other side. Everything looks like it's just peachy, resolved, we're done. But you're waiting now for that check to clear, which can sometimes be fairly quick. Other times it can take a week or two. And in the meantime, that client's financial situation is really bad. So this opinion concludes that in that situation, no longer pending, no longer contemplated litigation, you can provide an advance of the client's settlement proceeds if you comply with Rule 1.8A. 1.8A is basically the business transaction with the client rule. It says that you can enter into a business transaction with a client provided that certain conditions are met, such that you advise the client in writing of the advisability or the interest in obtaining independent counsel. The terms are fair and reasonable and things of that nature. And the opinion sets out a couple of different terms, some specific requirements for what the committee determined were fair and reasonable terms. Things like, if that check ends up kind of bouncing, the lawyer's taking on the risk of advancing this money to the client. And if the check bounces, you, lawyer, aren't going to go and sue your client subsequently. There's a couple of different terms that are in there, and I would encourage you all to take a look at that opinion. Again, that was adopted probably the latter part of last year.
Let's go back to the general rule, because my involvement with the DHC and then more presently on the grievance committee as a counselor, I'm more familiar with the situations where lawyers are representing clients and they get into either a friendship or maybe even a romantic relationship, which is not advisable, and the client is in financial straits, and the lawyer ends up saying, you know what, I'll help you out with your car payment this month. And I've seen a lot of lawyers, I mean, statistically, I don't know, but it seems like it's not infrequent that lawyers get in trouble for advancing, making car payments, making mortgage payments, loaning money, that kind of thing.
Right. That's something that is very, it's understandable from kind of a human perspective, but it's still prohibited. Again, we don't want to get into the weeds of why that's prohibited. I guess just very generally, the notion of prohibiting that type of financial assistance is to ensure that the lawyer isn't essentially inducing somebody into some sort of litigation that they otherwise would not pursue. The question of whether a lawyer is essentially luring clients over to their business because they happen to have deeper pockets than anyone else and can offer financial assistance during the course of litigation, that would present an unfair advantage to get clients where the client is making decisions based upon their need and desire to get money now, as opposed to who can represent them the best. But it is generally prohibited. It's a great example of the tension that we experience as lawyers between wanting to be human beings to each other and recognize when someone's in need and we can help them, versus the requirements and the responsibilities that we have to the profession, and to respect the attorney-client relationship to ensure that it remains as effective and pure as possible.
Let's go to the next one, and I just want to touch on this briefly. This is about being aware of fraudulent transactions, wire fraud, advising clients of the same. And I think without going in too much in detail, because I want to get to these some of these other issues that we have time for, I think this is a situation where all lawyers ought to be aware of all of the issues that are out there today about wire fraud, and have in place some pretty serious and strict safeguards before money is being transacted or advanced or what have you. So I think if a client is wiring you money for any particular part of the case, that they need to be advised that, once this is commenced, don't email me and say you want to change the wire instructions. If you want to change the wire instructions, you're either going to have to call us on the phone and identify yourself, or you're going to have to come to our office to take care of it, because we've got safeguards in place and we're not going to vary from those safeguards. The risk is way too high.
I think that's right, Fred. This is one that we have seen at the bar in the grievance process time and time again, where some criminal out there essentially intercepts or spoofs an email, something like that, and deters or or changes the course, the pathway of funds that were supposed to go from client to lawyer or lawyer to client, and basically steps in the middle and ends up getting those funds directed to the criminal's bank account. It's been going on for a long time. Lawyers are often the targets of this. And so this opinion just expresses the reality that lawyers need to be aware of this and inform their clients. And like you said, Fred, have those safeguards in place to ensure that entrusted funds, or that funds that are intended to be entrusted, are fully protected.
So let's go to this next one, which is going to generate, I think, a lot of interest and a lot of discussion. And I want to kind of go back to, I think it is 2015, when the rule concerning ex parte communication with judicial officials was modified. But that 2015 rule is still with us, correct?
That's correct. And I realize here that I failed to remove the word proposed. This is no longer proposed. This opinion was adopted just a couple of weeks ago. So please ignore the word proposed on here. But yes,
what is the site? Is it a 2020 or?
It's still 2019 FEO4. That's
Okay.
that's the opinion you can find on the State Bar's website. So generally speaking, the overall rule on ex parte communication, you have it here before you, and this is different than it was, 5-6 years ago. A couple of years ago, there was kind of a desire to take a look at Rule 3.5 on ex parte communications. I believe there was a change in the model rules, so we just wanted to take a look at it and see if it needed updating. One of the things that got updated, there was previously an exception to the ex parte rule if you copied opposing counsel on the communication. That exception was in there for some time.
Let me interrupt you. That exception was pre-2015.
That's correct.
Okay.
Before 2015, there was an explicit exception saying something was not considered ex parte if you copied opposing counsel. That exception was removed in this new version of Rule 3.5, and it raised a lot of questions about, well, what do we do with communicating with judges? Can I copy opposing counsel and it not be considered ex parte anymore? Because now the rule says this: a lawyer representing a party in a matter pending before a tribunal shall not, unless authorized to do so by law or court order, communicate ex parte with the judge. Very just blanket sort of rule there. Down in sub D, we don't have B and C up here because B and C deal with juries, so it's not really applicable to what we're talking about here. But down in 3.5D, you have a definition of ex parte communication. Ex parte communication means a communication on behalf of a party to a matter pending before a tribunal that occurs in the absence of the opposing party, without notice to that party, and outside the record. And so we have this new definition of ex parte communication that I think still feels, fairly easy to interpret, but it raised a bunch of questions, with regards to how we're communicating today, particularly across different districts. It may not be the practice here in Wake County, but there are a lot of districts that really operate by text message. When you have somebody, say, out in the mountains, where somebody's having to go from Transylvania County up to Swain or what have you, and they have to make it in one day, but it's going to be a 2-hour drive. So they need to ask the judge, can you hold my case open until I get there in the afternoon? It's common practice for folks to just send a text message to the judge. Maybe they copy opposing counsel, maybe they don't. It raised a bunch of issues in our discussion in our subcommittee as we studied this issue. Because a lot of folks, again, they just have different practices and kind of different expectations in terms of judicial efficiency or inappropriate communication with judges. So where does the opinion come out? Well, the opinion essentially is trying to, it first kind of addresses the general notion that, of course, there are on the record conversations. Those are unaffected by this opinion. There's also very inappropriate ex parte communications, those very direct communications with judges that are exclusive without opposing party present, that are on the merits, they're substantive, those sorts of things are prohibited. what the opinion really explores are kind of those things that are in the middle, those informal communications that lawyers will have with judges, whether by email or by text message or some other method of communication. So here's where we come out with the opinion. Again, that direct and exclusive communication only between counsel and a judge about a case, even including administrative issues, those things are prohibited unless authorized by law or court order. Opposing party or opposing counsel must be copied on any informal communication with the judge about the case. We're talking about emails and texts and all that kind of stuff. So the opinion essentially carries forward or confirms that the rule that we were all used to, that copying opposing counsel on a communication would exempt it from ex parte communication. This opinion confirms that the old rule is essentially still in effect, even if it's not in effect in the text itself.
So let me run some things by you. I email the judge a copy opposing counsel, and I say, Judge, opposing counsel and I need to meet with you. Can we meet with you tomorrow at 10 o'clock and talk about the calendaring of this case? Something's come up.
Right.
Okay.
That's going to be okay under the rules. Now, I think the opinion, I will just kind of add that the opinion does kind of encourage folks, if you can, it's always going to be a bit more, I guess we'll call it the more professional thing, to give notice, if possible, to opposing counsel. Just to say, hey, I want to email the judge about calendaring. I'm going to shoot him this email. I'll copy you on it, and just let kind of go that route. But, ultimately what you propose is not a rule violation.
But if I email the judge and I say, Judge, can we meet with you tomorrow at 10 a.m.? I need to discuss with you the fact that the opposing party has violated your court order.
Right. That's the sort of thing where we get into another section of that opinion where we start getting into substantive discussions about the case, and how the opinion concludes that essentially, even if opposing counsel is copied, a lawyer cannot send substantive argument or things that are on the merits of whatever is pending before that judge to the judge, even though the opposing counsel is a part of the communication. The reason being that while not ex parte, that communication can be a violation of Rule 8.4D, which says that it's misconduct to engage in conduct that's prejudicial to the administration of justice. This generated a lot of discussion. And I think what you had proposed, Fred, is kind of right on that line, where you're kind of asserting as a lawyer that somebody has violated the court's order. Maybe you haven't gone into detail about how the order has been violated. Certainly that would make it even more egregious. But the bottom line is that when you are emailing about something like, hey, we need to talk to you about something. Do you have any time for us, tomorrow morning? That is pretty neutral, non-substantive, just asking for the court's availability. And that's not going to really be prejudicial to the administration of justice. It's when you start getting into substantive discussion via this informal method of communication, while not ex parte, that starts to become prejudicial to the administration of justice. Why? Because opposing counsel, just because they were simultaneously copied doesn't necessarily mean that they are simultaneously participating in that very communication. They may not see that communication until 7 o'clock at night, at which point judge and opposing counsel, the original communicating counsel, have already gone back and forth about something. Kind of the bell has already been rung. And that's a question about fairness and access to the courts that really the opinion tries to resolve.
So I just want to interject at this point. We're starting to get a couple of questions, and I would like to get through. We've got a lot to cover. I don't know that we're going to have time at the end. We might not, to answer questions, but I want to keep going because there are several things we need to cover.
Well, there's this question that just got posed, I think is really appropriate to this particular inquiry, this notion of when a judge invites you to. If a judge invites communication, the opinion is very clear that that's not really an issue with the rules. All right, if a judge invites the opinion, because you can see the definition of an ex parte communication, or even the notion of prejudicial to the administration of justice. If a judge orders you or invites that sort of communication, then that's not going to be prohibited by the rules. I think it'd be appropriate for the lawyer to respond. It's really these kind of spontaneous, unilateral decisions by a lawyer to just provide substantive argument and just copy opposing counsel. If that happens, that, according to this opinion, is a violation of the rules of professional conduct. Should you then report to the state bar? That's maybe a different question of whether or not it rises to the level of reportable conduct under 8.3. But certainly, I think the opinion makes it clear that without a judge's invitation for that type of substantive argument, that would be a violation of the rules of professional conduct.
And we're going to get to the obligation to report in a little bit. Let's go to the next one, which is how you can or cannot respond to negative reviews.
Sure.
This online website. This is something that I'm familiar with. I had a negative review one time on our website, and we went to our marketing person, the person that was in charge of our website, and learned, and I'm not sure what the platform was, but the advice we got was, number one, because of the arrangement, we could not delete it. The advice we got was to bury it with positive reviews. But if you could address this, because it's not, we're not unfamiliar with this. It's happening more and more, and so many lawyers are having web pages and websites up, and it's going to happen.
Yeah, and it's incredibly frustrating. I recognize that. It's I was talking with somebody just a month ago about this very thing, where a client posted kind of excerpts of emails that the lawyer had with the client when the client was writing all this negative stuff about lawyer services, and was really just picking and choosing little parts. And lawyer was like, I want to provide the entirety of the email. Excuse me, can I do that? Because it's out of context. And my answer was no. You can't do that because just because the client is basically breaching their own confidentiality, that doesn't open the door for you to breach your duty of confidentiality. So this opinion basically says that I guess I'd boil it down to this: can you respond? Yes, you can respond, but you have to respond in a professional and restrained manner. That's the encouragement there. The absolute prohibition, though, is that you cannot respond with confidential information. You can't correct the record in this on this platform on Facebook or Yelp or Google or wherever you're responding by providing information that is otherwise confidential. Your duty of confidentiality still reigns supreme here. Ultimately, the big question, the technical question, was whether or not the self-defense exception that we see in Rule 1.6 applies. That essentially you can breach confidentiality if you are responding to a claim about your legal services. The opinion concludes that this is not the type of claim that is anticipated by that exception. That's really talking about something like if you're either establishing a defamation claim or somebody's asserting that you engaged in malpractice and you need to reveal confidential information to establish that you in fact did not engage in malpractice, that exception applies in those scenarios. This is not that scenario. Online reviews, as frustrating as they are, and as potentially detrimental they can be to your reputation, that this defense does not apply. What is the response that suggested is essentially that you could respond in the review by just saying, I disagree with your assertions. I disagree with your restatement of what you consider the facts, but I have a duty of confidentiality. I cannot respond fully to these allegations. But I'd be happy to talk with you further. You can contact my office and I think that's one of those things that, you can respond, you can say you disagree, but you just can't reveal client confidences in your response. And I always try to encourage folks to remember, you're not responding to just the individual that wrote that negative review. You're really responding to everybody who's going to see that. So this is an opportunity where choosing professionalism may actually really benefit your practice in the long run.
So the defense exception would apply in a malpractice claim, but it would also apply if you got a grievance from that client or from anybody.
Absolutely, yes.
Let me play that out a little bit further. Let's say you got a grievance not from the client, but from the client's uncle. or the client's neighbor. And it's a grievance that you have to respond to at the state bar level. Can you reveal confidentiality at that point?
Yes, you can. That's one of those things that, again, that's another exception that comply with the rules of professional conduct and the rules of professional, or you can reveal information that's confidential to comply with the rules. One of the rules, 8.1, deals with disciplinary matters and says that a lawyer is required to be honest and forthcoming when responding to any question involved in the disciplinary process. So that's something where, yes, even if it comes from someone other than the client, you could respond with client confidences. You can also rest assured that the grievance process is entirely confidential. It's not subject to public records law.
Okay.
Or anything like that. So that's why that exception exists, that essentially the disclosure of that information is really into kind of a universe that is already locked down.
Okay, so let's go to the one that I jumped ahead on too soon.
Sure.
One about confidentiality, and let's go back to that hypothetical that I posed where I learned something about the case through my client. It later in court, it plays out. I still can't talk about it without the client's consent.
That's right. And this is based upon what we've labeled proposed 2020 FEO 6. This was published in October. We received the most comments on this opinion that I've ever seen. And there were a lot of folks that disliked the opinion. So it is back in subcommittee now, but it's one of those things that the answer to your question, Fred, is that yes, you're correct. You cannot disclose information that you acquired during the course of the representation, even if that information is subsequently put out in the public record. That's what Rule 1.6 covers. And I think in conversations about this proposed opinion, there are a lot of different questions that were posed to us and me specifically that just kind of indicated that I think maybe it's been a while since we've all really looked at the text of Rule 1.6, and maybe we envision Rule 1.6 and the duty of confidentiality differently than what the rules actually anticipate. I'm not going to go through this hypothetical. This was kind of like the origin of the story, but it essentially deals with that very issue that Fred posed. Somebody, a lawyer, having information about the client that they want to give a CLE presentation, a podcast, media interviews, anything like that. And it's all information that was in the public record. But the client essentially said, please don't do that. Please don't do that. I don't want to hear my client or my lawyer's voice on, on Good Morning America or a podcast or whatever, talking about my case and my information. And the question came to us is like, well, do I have to obey my client's wishes? Remember that the duty of confidentiality originates out of Rule 1.6, and it says generally, a lawyer shall not reveal information acquired during the professional relationship with a client. Super broad, right? It's very, very broad. But what is this information? Where does this information come from? You can see in the comment reiterated time and time again that it's talking about information relating to the representation of a client, not just information provided by the client, but it's information related to the representation. Comment 2, information acquired during the representation. And then comment 3 emphasizes information acquired during the representation, whatever its source. So we're talking about an incredibly broad statement about what is considered confidential. It's not attorney-client privilege. It's not work product. Those two things really kind of exist under the umbrella of confidentiality, but confidentiality is a much bigger umbrella than just privilege or work product. So it's all information. You cannot disclose that information unless the client gives informed consent, the disclosure is impliedly authorized to carry out the representation, or there's an exception that applies. In the scenario that was posed to us by this person, the client that says, please don't talk about this stuff, clearly he wasn't consenting. Clearly it wasn't necessary to carry out the representation because the representation was over. And then we had to look at, well, is there any sort of exception? There's really no exception that's applicable to that scenario where a lawyer essentially wants to engage in media interviews about the case and his experience, his thought process, and I guess especially against the client's wishes. So the opinion ultimately comes out saying that a lawyer is prohibited in that scenario from commenting publicly about information acquired during the representation unless the client consents or that disclosure is permitted, including information that's in the public record. Some things that we were talking about in subcommittee is really, whose information are we talking about? We start realizing that the information we're talking about it's not the lawyers, it's the client's information. So should the client have a say in how his particular scenario is played out or is disseminated to the public? You know, this notion of, well, it's generally known, isn't that an exception under Rule 1.9? I remember seeing that word. If something is generally known, I'm not prohibited from using it. That's not how it works. 1.9C deals with generally known information in an entirely different context. It's a very specific scenario where you can use generally known information. And the opinion tries to emphasize that hypotheticals are okay. You can still talk about things hypothetically. You just can't talk specifically about something. And if you talk about it hypothetically in a way that everyone knows what you're talking about, well, that's actually potentially breaching confidentiality.
So, Brian, we're as I thought, we're kind of running out of time right here, but I want to talk about an issue that's related to confidentiality. It's not about whether that information is within the public domain, but this is a situation where, and it actually happened to me one time, so I'll speak hypothetically about it. But I'm representing the wife, and the wife has a 401k, and the husband, who is a lawyer, fraudulently signed withdrawal documents, forged his wife's signature on the documents, took a withdrawal from the 401k without her consent, without her knowledge. And so I'm at a crossroads with my client because she's got a significant child support claim, a significant alimony claim. She does not want him to lose his job as a lawyer. But I'm concerned about a couple of things. One, I have to bring it to the court's attention because it's an issue in equitable distribution. He has taken marital property and it's now in his column, so to speak. The second issue is he's a lawyer. I know this information. It's a felony. Do I have an obligation to report? And I'm conflicted about it.
Yeah, that one, you know, the first aspect of whether or not you have a legal obligation to bring it to the court's attention for purpose of equitable distribution is something that the rules won't really speak to. You know, that's going to be something that's kind of outside of our purview. But the question of reporting is a very interesting one because you're right. The duty to report under 8.3 requires a lawyer to report another lawyer if that lawyer, the reporting lawyer, knows that another lawyer has engaged in conduct that raises a substantial question about the lawyer's trustworthiness, fitness, or fitness as a lawyer, or honesty as a lawyer. In that situation, you're clearly dealing with something that raises a substantial question about that lawyer's fitness, trustworthiness, or honesty as a lawyer. There's a question, I guess, you know, we're going to kind of go past the word knows because you do need to know to trigger that reporting requirement. You need to know that the misconduct in fact occurred, and you know we're going to kind of presume that you've satisfied yourself that you have knowledge that this actually occurred as wife has described. The thing that is tricky though is 8.3C does not require reporting if the information that you've acquired that you need to report was acquired during the course of representing a client. And that information is essentially deemed confidential under 1.6C. In other words, the reporting requirement that we find in 8.3 does not overrule the duty to the client to keep their confidences. So what I would recommend would essentially be to have a conversation with your client to say, this information is bad. I would ordinarily have a responsibility to report this person, to report your husband to the bar or to the court for disciplinary purposes for a violation of the rules of professional conduct. However, I can't because this information is confidential. Will you allow me to report this? And if the client does not consent, you do not need to report under 8.3.
Yeah. So I get calls from time to time from lawyers who say, hey, I want to run this by you. Do I have an obligation to report this? And we talk about two aspects of that. One is knowledge is a tricky thing.
Yeah.
do you actually know that this conduct occurred? And that generates a pretty interesting conversation. Number two is, does it fall within the language of, does it raise a substantial question as to the lawyer's honesty, trustworthiness, or fitness? And that's also an interesting conversation that I have with people, and leave it up to their discretion. But it's my understanding that there have been no disciplinary proceedings brought before the DHC on this issue. Is that correct?
To my knowledge, no.
Yeah.
I'm unaware of anything. I think there may have been, historically, I'm sure I could find something where somebody failed to report someone, but on this particular issue, where the information has come from a client or during the representation, and the rules are pretty explicit.
Okay. So where are we here in the next?
So looking at frequent rule considerations, this is kind of our chance to review that which you already should know. And Fred, I think you can talk about the types of complaints that you've seen in your role when you were chair of the Disciplinary Hearing Commission, and certainly on the grievance committee now with the State Bar Council, the types of complaints that you see come through the grievance process.
Yeah, and also spent some time with the local grievance committee. I would recommend to all of you, if you have a chance to participate with your local grievance committee. Wake County has one. It was some of the most interesting service to the bar that I've ever been involved with. About a third of the cases are clear cut, and about a third of the cases are, this is just somebody who's mad at their lawyer or the opposing lawyer. And about a third of them were absolutely split decision, vigorous debates about whether there was a rule violation or not. But one of the advantages of being involved with the local grievance committee is that you really dive into the rules, and it's quite an education. I would say about these things that are on the screen right now, staying in touch with your client and returning phone calls is got to be at the top of the list. If you ignore a client and don't return phone calls, and then it gets easier and easier to not return that phone call, it'll get worse and worse. It really will.
Absolutely. We see a lot of other things that kind of spiral from domestic cases. When one thing just kind of compounds on itself, there's always the communication issues, but sometimes that can result in neglecting cases. There's failing to refund unearned fees, conflicts, failing to withdraw, or assisting a client in dishonest conduct. We kind of see that stuff stem from different domestic cases from time to time. Fred, do you want to talk about RPC 212? Because I think it's always an important thing to remember, the responsibility that really this, or the opportunity that this opinion presents to lawyers.
Yeah, and then I have a question for you. So this is a situation where you filed a complaint, an answer is due, the answer is not forthcoming. Is it a violation of your duty to the client to pick up the phone and call the opposing counsel and say, hey, is there a problem? Your answer is due. This is something that you can do under the rules.
Absolutely.
The duty to the client. My question to you, Brian, is I'm going to assume that that's the same case with not answering requests for admissions.
I would say so. Yes. This is where it kind of highlights the general notion. Now you see there's a reference to Rule 7.1 here. It's actually Rule 1.2 now. This opinion is from before we recodified everything. But it really brings up this general notion of professionalism that is permitted in the rules of professional conduct. I think this is a message that everybody should take home, and especially in this pandemic when things have just been kind of all over the place. Rule 1.2 allows a lawyer to essentially be professional, to be gracious. You can see there in 1.2A2, a lawyer does not violate this rule by acceding to reasonable requests of opposing counsel that do not prejudice the rights of a client. by being punctual and fulfilling professional commitments, by avoiding offensive tactics, by treating with courtesy and consideration all persons involved in the legal process. A3 goes on to say, in the representation of a client, a lawyer may exercise his or her professional judgment to waive or fail to assert a right or position of the client. So whether we're talking about default, you're talking about somebody who's failed to respond to requests for admissions, you could go that route. You could go and seek default. You could get that stuff deemed admitted, pursue all those different tactics. But if you feel in dealing with your opposing counsel that something else may be going on, that this may be a time for grace to be offered, even if the client says, no, go for the jugular, but you want to say, hey, I'm going to pick up the phone and say, your answer was due yesterday. Are you planning on getting this to me? And even if they say, I can get it to you tomorrow, I'm so sorry. You can be gracious and you can say, yeah, let's go that route. It's that kind of longstanding thing that what you can do versus what you should do can sometimes produce a different result.
And here's a practical aspect of this. In that situation, what I would tell the client is, if I go forward and get a default on this matter, there is a likelihood that the lawyer is going to file a motion to set that aside.
Right.
And there's a decent chance that might be set aside, and he or she might be allowed to answer. So do you want to spin those wheels when there's a likelihood that this is, going to be resolved in the end?
Right. That's exactly right. And I know we're butting right up against 3 o'clock here, Fred. I don't know if there's any particular point that you wanted to get to. The next thing that we're going to touch on was, some reminders about the duty for the candidate to the tribunal in terms of being honest. And there's a number of older opinions that illustrate this constant duty of being honest to the court system and honest with opposing counsel for that matter. But certainly there's a lot of different opinions on these different scenarios where it may be more advantageous to your client to kind of hedge on some things, but ultimately we have a duty to be honest and forthright to the tribunal.
Let me jump in and get to my last point, and it's about mediation. This is an issue that kind of snuck up on us a few years ago, or a couple of years ago, and it goes like this. If you practice law with other lawyers in your firm who represent people in family law cases or who mediate, the rule we were all familiar with was that if your partner or other lawyer had represented someone in a family law case and you were asked to mediate, the answer was yes, you could if you got a written waiver. And we would typically do the written waiver by email. The Dispute Resolution Commission, however, came out with a rule that said you may not. And so it works in 2 different ways. One, if you have mediated a case, you are prohibited, and anybody in your firm is prohibited from representing a party that was involved in the mediation that you undertook. And the reverse is also true. If somebody in your firm, partner, associate, represented a person, and that person now wants to come in 6 months later and have you mediate the case, that is prohibited also. And it's a may not. There's no waiver exclusion. If you disagree with this rule, I invite you to write the director of the Dispute Resolution Commission. I was fine with the state bar rule that would allow it if it was a written waiver. But I want everybody to be aware of this because not everybody was. I think we're out of time.
I think we are. Thank you, everybody, for having us.
Thank you.
This was fantastic. I really enjoyed this presentation, and I'm certain that a lot of people here enjoyed it as well. Thank you so much for your time and your expertise, everyone.